Okay, ladies and gentlemen, gentlemen and ladies and gents, it is past my bedtime. I've been up since 4 o'clock and it's 8 o'clock now, so that's 14 hours. Been working on a whole lot of stuff. If you can pay attention over the past day, at least 5 videos have gone up. Not because I've done 5, but there were 2 videos done, I believe yesterday or earlier this week, that if you look at the date stamp, you'll see that they were done a week ago before the individuals decided to do what they did. Now, I already knew they were monitoring me. I already knew they were tracking me. It's okay. They've already shown me the paperwork showing that they were doing that. And so they knew the information I was trying to put out, and before I could get those videos up, all of that happened. But if you were to pay attention, most of the information had already released anyway. Ladies and gentlemen, we're going to talk about this process because I think there is still some confusion. Despite all of the videos that I've done trying to explain this to all of you, I think there is still some confusion. So my hope is that we'll clear up most of the confusion now. We've known that the government in America, the government in every other country, has been doing what's known as contracts with its citizens. Now, many of you knew about the birth certificate and how that was a contract with the government, that it is the only contract that you and the government signed together. Every other contract is just your signature. Take a look at the DMV when you go there and you sign the paperwork. Well, please understand, New Hampshire went ahead and solidified it for me. When they put up the law in New Hampshire, let's see if we can pull that up for a second, just so that you can see about the contract thing, because again, that's the important part. Uno momento, momento. I think it's behind here. What's behind door number 1? This is the New Hampshire bill. See, text New Hampshire bill. And let's do that. Hey, they have a methodology. The bill repeals laws requiring a driver's license for all non-commercial drivers. Ladies and gentlemen, they could not have had a bill that made it to where you needed a driver's license for a non-commercial driver's license. I mean, for a non-commercial driver. But that's what it says this bill did. But let's go ahead and... Oh, well, we can't pull it up because it's not the actual bill. This is the kill bill. And so, but we're still going to show it to you nonetheless. You see right here, it says this is the act, but it's not the act. This is just the fiscal note. So this is all the funding and all of that. I don't need this, and I don't know how I got to this, but all I wanted to do was show you guys. Oh, there it is. Whew. Okay, let's get that out of the way, because I'm like, all I need to do is just show you guys where they done told us everything. New Hampshire, out of all the places on this planet, New Hampshire decided to be honest with the people. This is the section we're talking about, the one that says statement and purpose. And because my screen is moving so slow, but this is the section right here that we're referring to. Oh, it won't even let me move the screen so that I can minimize, put it in the middle. It's moving so sluggishly. So let's see, there we go right there. Nope, too much. See, every time I get it to where I want it, it wants to do what it wants to do. All right, stop, don't move no more. All right, pay attention. Statement of purpose, the general court, that means all of Congress, and you got the Supreme Court of the state agreeing, and the governor for the state, finds that the authority of the Department of Safety, which is the Department of Motor Vehicles, is limited only to commercial users. That's why you keep hearing people say that they can only deal with the fiction. They cannot deal with the human. Okay? New Hampshire is saying the same thing, that they only have authority over commercial users, especially when it comes to the public highways. Why? Because the public highways are there for the private transference and conveyance of individuals. That's why they can't tax you on it. They can only tax you if you're operating in commerce. But we're not here to talk about that, okay? And that the corporate state employees, that means the DMV, the state troopers, the FBI, the CIA, all of those corporate state employees, all government is corporation. Government is a corporation. Don't worry about the U.S. means a corporation. That's a misnomer, because that's the, what do you call it? The Federal Debt Procedure Act. Debt Collection Procedure Act. That's the Federal Debt Collection Procedure Act, where you hear that the United States means a federal corporation. Okay? All government is a corporation. No matter what government you go to, even if it's a monarchy, it's still a corporation. Corporation just means something that's incorporated, like a group of people. That's all it is. Even the people of the United States is a corporation. Don't worry about that. Don't get hung up on that little sideline stuff. Okay. It says that these state employees have, by their silence, failed to fully inform the sovereign people. Look, ladies and gentlemen, there's nothing wrong with being a member of the sovereign people, because the people are sovereign as a whole, not a citizen being sovereign by themselves, but the people as a whole. So somebody wants to call you a sovereign citizen, say, yes, I'm part of the sovereign people. Is there a problem with that? Do you not recognize the people being sovereign? Okay, because if you go to look at all the case law, it says that the people, the sovereignty, rests in the people. The people. That's a group, not a person. Okay. Failed to inform fully the people of the state that an automobile, a home, household goods, consumer goods, has been confirmed by the courts to be private property. So, ladies and gentlemen, any of your private property, you cannot be taxed on your private property. They cannot force you to register your private property. Okay? That's what this is saying, but nobody's going to read it that way. New Hampshire had to be careful when they worded this, because if they had come straight out and told you exactly the way I'm explaining it to you through statutory interpretation, that's right, there are 9 principles of statutory interpretation. So by interpreting this, and I have every right to do so, because all of you are supposed to be knowledgeable about law as well, because ignorance of law is no excuse. Got to get it going. All right. They cannot tax you on your private property, but if New Hampshire had come straight out and said this, they would have caused harm to the agency, which would have made all of them liable. So thus they had to put it this way. As defined in UCC Article 9, Section 109. Now you notice how they didn't put UCC. They put their own state revised statutes, but they did not put UCC 9-109. No. You had somebody like me telling you that that's UCC Article 9, Section 109 and Article 9, Section 102. Go and read it. You'll see that it lines right up with this. It talks about household and consumer goods. It's not for commercial use or for profit or gain. Further, the courts, the federal courts, as we've shown you on the website, the federal courts have found that the corporate public servants who ignore their accountability as mandated in the Bill of Rights have, by their silence and failure to fully inform the sovereign people of the consequence arising out of the corporate offer to contract, is deemed silent deception and inducement to fraud. So New Hampshire told us all about the fact that government was doing what's called an offer to contract. Everything is an offer, ladies and gentlemen. That's all they're doing, is making you an offer. Let's make a deal. Well, when was the first time you were aware of them making an offer to you? Well, it was called the New Deal. That was Franklin Delano Roosevelt. He was creating a new contract. That's why they created all of those programs. All of those different contracts. Social Security, what do you have? Homeowners insurance and this insurance and that insurance. They made everything insurance back in 1933. Everything became insurance, one way or the other. That was the New Deal. That was the new contract. Ladies and gentlemen, that contract is still in force, as we've shown you. Congress has indicated by the National Emergency Act and the Committee on National Emergencies of 1972, 73, 74, 75, that the acts of Congress and the act of the President of Proclamation 2039 are still extant, still in existence this day, still operational. Well, if that is the case, guess what they did? So that you all know, they just keep adding to the contract, ladies and gentlemen. They're not giving you a new contract, they're continuing the same contract. The same contract that involves the maintaining the trust, maintaining the infant accounts, being trustees over the estates. They are still trustees over the estates. The estates are not bankrupt. It is the United States administrative government that is bankrupt. Okay, so just get that. The United States as a country is not bankrupt. It is the corporation that is bankrupt. But now pay attention, the entire world is bankrupt. Everybody who's part of the so-called World Trade Organization, they are all bankrupt. They're all trading in worthless paper. And it doesn't matter if they have $85 quadrillion in gold. They are still bankrupt. And it will take people some time to finally realize that and get it. But most people are still stuck on, what's the word, stupid? And they're going to be there for quite some time. Okay, the world is bankrupt. Why do you think they're going to have to reset the system? Why do you think they're going to try to destroy so many people? Why do you think they're going to try to kill so many people? Because it's not sustainable. The system that they've created is not sustainable for 8 billion people. You cannot keep this fantasy going for 8 billion people. You can for 2 billion. That's what it's designed for. That's why they keep complaining about it growing too big, because they can't run the organization the way they want to run it. They can't keep doing things the way they're doing it now. Too many problems with it. And they don't have any other foreseeable future because they can't control the markets. They can't control commodities. Look, ladies and gentlemen, I don't care if you are living in an $8 million home. I don't care if you're living in a $7 million home. I don't care if you're living in a $150 million home. You still have doors. You still have knobs. You still have closets. You still have brooms. You still have shoes. You still have clothes. You still have carpet. You still have floors. So what makes that property worth $8 million? What makes it worth $100 million? Absolutely nothing. There's nothing in that home that makes it worth $1 million. There's nothing in that home that makes it worth $2 million. People say, well, it's the land. No, it can't be the land. If the land made it worth $8 million, then there must be gold deposits in that land. But there's no gold in the land. You go out there and dig up the front yard. Hey, they still have to water their front grass the same as you have to water yours. They still have to pay for lawn and gardening and upkeep and trimming of the yard. But it's $8 million. They shouldn't have to trim nothing. It should trim itself for $8 million, huh? Because people are not understanding. That value is only inflated value, somebody's opinion. It has nothing to do with the actual value. That's why there's this thing called depreciation. People are not getting it. So, back to the story at hand, ladies and gentlemen. Government created a contract, and in that contract they created an illusion. That is what the matrix truly is. The matrix is the contractual system. See, everybody is disillusioned, and the illusion is basically seized hold of everyone because they're involved in contracts that they don't even know exist. They got all kind of papers in the mail and they call it junk mail because you guys are not reading it. You call it junk mail. The first thing I do whenever I move to a new place is I stop the junk mail from coming. Well, we have to deliver that, is what the post office says. Excuse me? No, you don't. So I call each one of those companies that's sending that to my house, and I tell them, you need to put a stop to that. Don't send that junk to my house. I don't want it. I didn't ask you for it. And I stop it immediately. Why? Because I don't want nobody sending me something that I throw in the trash. The same thing that they do with your contract. So let's talk about it, shall we? Ladies and gentlemen, there is this thing called Unilateral Contract. And basically, it's una, meaning one person, signs it. Now what happens? Well, let's do the mortgage agreement. As we've spoken before, you go, you tell the realtor, hey, I want to buy a house. Realtor says, okay, I'm going to run your credit. You say, okay, here's my stuff. There's my ID. There is my social. Realtor says, okay, now I'm going to send this to our broker. We're going to see if we can see how much you're worth. See how much we can get for you. Hey, you've been approved for a $150,000 loan. You go, really? That's right. So all you got to do is go out there and find yourself a $150,000 home. You think that's going to be easy, but that's not easy. Because $150,000 doesn't put you in a good neighborhood, and you want a good neighborhood for you and your children, but you're so happy just to get that loan, so you go and you look for that $150,000 so-called valued home. You find it, you go back to the realtor, hey, I found a home. Realtor goes, really? Well, tell you what, we're going to do an inspection, we're going to do this and that, but don't worry about it, we got you back. A couple of weeks later, hey, we got you your funding. Guess what? We have some papers you need to come and sign. Oh, don't worry about it, nobody's going to be there but me and a notary. You don't have to worry about it. Don't be afraid. It's okay. We're going to make it as peaceful and as pleasant an experience as possible, because we don't want to scare you away, because we need you to come in and sign these papers, because there are so many contracts associated with this, adhesion contracts and everything, and so we need you to come on in here, okay? We're going to try to do the best we can to keep you relaxed, cool, and calm, and then as soon as you leave, we're going to have a party, and we're going to be laughing at you, and we're going to be saying how stupid you were to come in here and sign all them contracts without reading them. And that's what they do. So you go in there and you sign all those documents, but wait a minute, they didn't tell you that that was several contracts. They only told you that it was just closing documents. They actually refer to it as closing documents. Do you understand? That's what they do with a coffin. They close it. So you're getting buried in paperwork. Signing all of those contracts. Shame on you. And you didn't even realize it. Okay, so let me explain to you what's going on so that you get it, because it is necessary that you understand. You sign those papers. Nobody else signs them but you. The notary comes and says, okay, I witnessed them signing that. And the realtor witnesses it. And there you go, you got two witnesses showing that you signed that contract. So now you're bound by that contract, because two witnesses is a charm. At the mouth of two or more witnesses, a matter is firmly established. It's a biblical principle. You have the notary and a realtor. That's why they're there. Okay. Now, what do? Well, they take this new contract that's only signed by you. They take it and they deliver it to the bank. Okay? Tick tock, tick tock, tick tock. Wait a minute. 8 years have gone by. The bank's now saying you owe, and they go to court. And what is the first thing they do? They put in a copy of the contract where they never signed it. You're the only person who signed it, and people were going in, I'm the only one who signed that, Your Honor. Nobody else signed that agreement but me. They were going into court saying that. The judge is saying, you moron. This is a unilateral contract. They didn't need to sign it. All they needed to do was be notified that it existed. And here they are, they have a copy of it, and they put it into the record. That shows me that they knew of its existence. Okay, so now you're bound by the terms of that contract, and they are saying you're in default. You got any proof you're not in default? You go, no, Your Honor, I didn't even know. I was just signing them papers. I didn't know that was a part of it. Your signature's right. That's your signature, right? Yeah, that's my signature. Okay, well, you're as guilty as sin. You ain't keeping this house. I'm going to give it to them, because this paperwork says I get to do that. And if you don't like it, too bad. And so you get kicked out of your house. You get foreclosed on. You get to go bye-bye. You get to go, I'm living out of my car with my wife and children right now. Okay? It's a wonderful story. So let me tell you what we're doing. What we're doing is we're creating the closing documents. We put them online for you. We did the one for incarceration now. There are some tweaks that can be done to that document, but for right now we needed to put it out there. And we have several statements in there that said it is to be construed contextually. If you take a look at the wording of that document, take a very close look. It is solidified to protect you, but it's also solidified to protect them as well. Okay, because it has to be a contract that will stand the muster of scrutiny. So if anybody was to come in and say, this is too lopsided, that gives them all and it doesn't give enough consideration and value, and there must be value and consideration and all that, we took care of it, so there's nothing of that. So if you look at that contract, you'll see that the contract is quite specific. As a matter of fact, let me pause. Okay, now as we told you, we were going to call it the Incarceration Contract. So the very first words of it are incarceration. You will find it up on the website, under the PDF section, under the private law arbitration files, and the title of it is incarceration. So when you see that, that's for the people who are incarcerated. If you take a look at the document, as soon as it pulls up now, sorry, a lot of programs on this computer, and so the word takes a second to pull up because it has all of them plug-in things. So it's taking care of the plugins. But anyway, so that you all get it, it has a ton of case law in that document, which proves every single point that's being said. Because see, you go into court and you bring these case laws and they don't want to hear it. They ignore it. Well, now they can't ignore it. Why? Because for one, Congress, and this is what I am doing, and I'm hoping the rest of you will join the bandwagon, Congress has said that all of those points raised by the guys, Mr. Stark, Mr. Bradley, Christopher Stark, who I need to get in contact with this week, he's actually nervous about talking to me because he doesn't know how to communicate with me because he doesn't really know me. And I'm trying to let him know that he doesn't have to do that at all because of the amount of respect I have for him, that he was able to take the little bit of information he already had and he figured this out. See, the only thing he did that we didn't do, we did something about 6 years ago called the All U.S. Corp Stock. And I refer to it as the All U.S. Corp Stock. Ladies and gentlemen, where it was sent to all U.S. corporations, the only thing we didn't do with that contract is we did not put in the arbitration clause. And I'll tell it to you because ain't nobody else gonna say it but me. We didn't know. We didn't know that it needed an arbitration clause in order to avoid the courts. See, people were trying to figure out how to enforce their instruments. You enforce it through arbitration, people. That is the kicker. Now, we showed you in the video, and if you guys have been paying attention, go and watch the video where we tell you about Congress trying to stop this. And we showed you the timeline, how it was right after these gentlemen did this, that all of a sudden they want to stop it because they see the same thing I see. And as I told the gentleman, when one of them got out of jail, the first thing they did was they went online, they were checking some things, and they found my video. Had Starks had stumbled onto maybe one or two of my videos in the past, but this individual had never seen my videos before, didn't know who I was, but he stumbled onto it. And he said to himself that I sounded like I knew what I was talking about, and he was going to go out of his way to get in contact with me, and he did. He found the number, he contacted me, and I spoke with him. When I spoke with him, it was really plain and simple, ladies and gentlemen. I simply told him the same thing the attorneys told him: you can't do that. Well, as you see, I've changed my tune. You better believe they can do that. You better believe they can do that. Okay? You better believe they can do that. I realize that now. And so that's what I'm telling them, is I'm on the same trip, bandwagon, and everything else that they own. I'm a fan of them. Okay. Ladies and gentlemen, as we said, the way this is written up, there are some things that when it talks about certain things, you can take that out. But we're saying don't add too much to it and do not change the structure of the document. Do not start taking away certain things that you would be responsible for if they honored this agreement. Let me explain to you why they can never honor this agreement. Okay, do you want to know why they can never honor this agreement? Let's go down to some of the case law. We're just going to pick one at random. Let's pick this one right here. Proof of claim: the proceedings in which the named defendant and the undersigned were subjected to within the above reference alleged criminal case cause were not in equity or chancery, and that the conflict was not with the on non-constitutional source of authority for the existence of the statute of laws alleged / charge as violated within or upon the face of the warrant of arrest, charging document / instrument, indictment, and affidavit in support thereof. Okay, you guys need to understand, no matter how they answer, they are admitting that what they did was wrong. There's no way around it, because they have to answer with specificity. There can be no non-answers. There can be no, we don't know what you're talking about answers. They have to provide an answer throughout the whole document. Now, that's just one of the case law, one of the proof of claims. Now, see, that's where Mr. Starks and them were ingenious. You see, they took and look at this proof of claim. Look at how much wording is there. A false or unlawful arrest is not in and of itself an assault, and an assault or battery, trespass, or graven offense, and the law does not regard such arrests as any other assault which may be resisted by the assailant or the assaulted. Ladies and gentlemen, they said proof of claim that a false arrest isn't this. Okay, please understand. They don't have an answer to this. Do you know why? They can only say, yes, that is true. They cannot say, no, that is not true, because he's given them irrefutable proof that it is, with the different case laws that he has here and their own statements. Okay, when they took and they made their proof of claim a question using the case law, that was ingenious, because it's a catch-22 averment. No matter how they answer it, it still proves the point. So the way the contract is written, that if any one of these points is true, then that means the entire contract is true. That means that every point in the contract is true. They added and I added, before I saw it in their document, I added that due process of law. The law says no one may be tried, convicted, and no warrant shall issue without due process of law. Well, if there is no due process of law, if they violate the due process of law clause for the individual, then that means the arrest, the incarceration, and anything that happens subsequent to that is illegal. That's what it means. That's what the law says. Well, they pulled up the case law for it. I only know the interpretation of the constitutional amendment, number 5 and number 4. Okay, so this is what they've done. And in this document that you're going to see, I think we left all of the points in this one. I think we took it to the river. Okay, take a look at, let's see, where are you at? I think that's all 500 and some odds. Okay, so those of you who have people that are incarcerated, one person asked, well, can I do this? My son is in jail, so could I sign for him? Ladies and gentlemen, as long as you get the person's permission, of course you can sign for them. You can sign for anyone who gives you permission to sign for them. Do you know that this gives you power of attorney? That's right. I went and got 40 power of attorneys notarized, where I got to sign the signatures of the Secretary of State for the United States and the Secretary of State for the United States, the United States courts, the California state itself, the Attorney General for the United States, the Attorney General for the state of California. I have the power of attorney because my contracts give me power of attorney over them. Guess what? This contract gives you power of attorney over the agencies for which you're signing. Now, when everybody is slowed down, because the first thing people want to know, well, how do I enforce it? Let me do you a favor. I'm going to do the biggest favor I can possibly do you, because this has been my stress, and I was hoping that I was going to be able to get this up. That's why I rushed to get it up today. That's why I said it could use some tweaking, but for the most part, it is done, because we took care of all of the caveat and the, the arbitration clause. So let's go ahead and go over the arbitration clause so that you guys can see what's going on with the arbitration clause, so that you can see why arbitration works. All right, and my internet is slow tonight because I am on a different plan. But this is our arbitration clause, and we call it a cognizable remedy at common law. Additionally, it is exigent. Exigent. That's the word I put there, and I'm sitting up here pronouncing it wrong. It is exigent and a consequence of the undersigned to inform the respondents in accordance with and pursuant to the principles and doctrines of clean hand good faith that by the respondent's failure and or refusal to respond or provide the requested and necessary proof of claims raised herein and above, and thereby it shall be held and noted and agreed to by all of the parties that a general response, a non-specific response, or a failure to respond with specific specificities and facts and conclusions of common law, and or to provide the requested information and documentation that is necessary and in support of the agreement shall constitute a failure and a deliberate intentional refusal to respond, and as a result thereby and or therein expressing the defaulting party's consent and agreement to said facts, and as a result of the self-executing agreement, the following is contingent upon their failure to respond in good faith with specificities, with facts and conclusions of common law to each and every averment, condition, and or claim raised, as they operate in favor of the undersigned through tacit acquiescence. The respondents not only expressly affirm the truth and validity of the said facts set, established, and agreed upon between the parties of this conditional acceptance for value and counterclaim offer for proof of claim, but the respondents having agreed and consented, the respondents having a duty and an obligation to provide the requested necessary proof of claims raised herein and above, will create and establish the respondents an estoppel in this matter, and all matters related hereto and arising necessarily therefrom. What I'm trying to say by reading this, and I'm going to read all of the arbitration section so that you understand, you don't have to add anything to it. We have taken care of you. We have protected you. As a matter of fact, I promise you, this thing has more points that are added to it that myself and the other guys that did it before you put in other documents afterwards. It was decided that it should go in this document, so we've covered all the bases in one document as opposed to doing it in several. In accordance with and pursuant to this agreement, a contractually consensual binding agreement between the parties of this conditional acceptance for value and counterclaim offer for proof of claim to include the corporate government, agency, department, construct whom the respondents represent serves, as well as all officers, agents, employees, assigns, and the like in service to the respondents, will not argue, controvert, oppose, or otherwise protest any of the facts already agreed upon by the parties set and established herein, and necessarily and of consequence arising therefrom, in any future remedial proceedings, actions including binding arbitration, and the confirming of the arbitration award in the Court of the United States of America. See, we added that of America part for you, not a district court. Before it said district court. We don't want to be in their district court. We want to be in an actual court of original jurisdiction. Let's continue. Or any competent court of original jurisdiction in accordance with the general principles of non-statutory arbitration, people, common law arbitration, wherein this conditional acceptance for value /agreement /contract, you have to create your own contract number. Okay, this you need to know. That's why the contract number here is different. Pay attention. You see it says 7001 and it's highlighted in yellow. The reason why it's highlighted in yellow, because you have to, this is a different number than this. These two numbers have to match. You have to create your own contract number. That's why we made them different, because it has to be your number. But we're saying make your number at least this long. And remember, keep your copyright simple. That's your number. All right, let's continue. Constitutes an agreement of all interested parties in the event of a default and acceptance through silence or failure to respond when a request for summary disposition of any claims and particular issues may be requested and decided by the arbitrator, whereas a designated arbitrator shall be chosen at random who is duly authorized, and in the event of any physical or mental incapacity to act as arbitrator, the undersigned shall retain the authority to select any neutral arbitrators that qualify pursuant to common law rights to arbitration, as the arbitration process is a private remedy decided upon between the parties, and with respects to this agreement, the defaulting party waives any and all rights, services, notices, and consents to the undersigned and or the undersigned's representative's selection of the arbitrator, thereby constituting agreement, and any controversy in our claim arising out of or relating in any way to this agreement, or with regards to its formation, interpretation, or breach, or any issue substantive and procedurally arbitrability, shall be settled by the arbitration, and the arbitrator may hear and decide the controversy upon evidence produced through a party who is duly notified of the arbitration proceeding, although the party who is duly notified of the arbitration proceeding did not appear. The undersigned deems necessary to enforce the good faith of all parties hereto within, without respects, venue, jurisdiction, law, or form of the undersigned deems appropriate. Basically, that lets you choose the arbitrator. Okay, you don't need their approval because they've given it to you through tacit acquiescence. But what if they respond? What if they answer every single question? Oh, well then there you go. You take it to the arbitrator, and guess what? They answered every single question, which admits their fault. There you go. Here's the paragraph where it took me some time putting this together because I had to make sure that you all understood the amount that you get to do it for. And then I'll explain about there being no money. This video will probably be a little bit over an hour, maybe 2 hours, because I have to explain this document to you, those of you who are doing it, so that you get it, so that you'll see. And remember, this is the same information that's in all the other arbitration documents. All the contracts we're doing will have the same arbitration clause. Here's the point: it won't have this dollar amount thing, but it will have the same arbitration clause. It says further, the respondents agree the undersigned shall secure or can secure damages via financial lien on assets, properties held by them and or their behalf for all injuries sustained and inflicted upon the undersigned for the moral wrongs committed against the undersigned as set, established, agreed upon, and consented to herein by the parties hereto, to include but not be limited to the constitutional impermissible misapplication of statutes, laws, in the above referenced alleged criminal, commercial, civil, cause, fraud, conspiracy, two or more involved, trespass of title, property, and the like, and all other known and unknown trespasses and moral wrongs committed through ultra-virus acts of all involved herein, whether by commission or omission. Final amount of damages to be calculated prior to the submission of tort claim and or the filing of lien or the perfecting of a security interest by a uniform commercial co-financing one statement, estimated in excess of $10 million. We're estimating, so it's not to say it will be in excess of $10 million. USD or other lawful money or currency generally accepted with or by the financial markets of America, as the value of this claim established at $25,000 per 23 minutes, $1.6 million per day, and punitive damage within the above referenced alleged criminal case cause. See Trezevat versus the City of Tampa. Dade County. No, Dade County is not Tampa. Tampa's a different county, sorry. Wherein the damages were set at $25,000 per 23 minutes for a false imprisonment case. So that's your base standard. If he got $25,000 for 23 minutes, that's right, they held him for 23 minutes, he got $25,000, which equates to $1.6 million per day. So it is not unreasonable for an individual who's been locked away for 30 years to do it 1.6 million times 30. Do you understand? That's not unreasonable. To do it for treble damages, that would probably be unreasonable. Okay? That's a suggestion that you don't do that. Not saying you can't. I'm just saying that's a suggestion. and notice the respondents by invoice. Per respondent's failure and/or refusal to provide the requested necessary proof of claim, and thereby therein consenting and agreeing to all the facts said, established, and agreed upon between the parties hereto, shall constitute a self-executing, binding, irrevocable, durable power of attorney coupled with interest. This conditional acceptance for value and counterclaim offer proof of claim becomes the security agreement under commercial law, whereby only the non-defaulting party becomes the secured party, the holder in due course, the creditor in and at commerce. It is deemed and shall always be forever held that the undersigned in any and all property, interests, assets, estates, trusts, commercial or otherwise, shall be deemed consumer and household goods, not for profit or gain, private property, and exempt, not for commercial use, non-taxable, as defined by the Uniform Commercial Code, Article 9, Section 102, and Article 9, Section 109, and shall not in any way point or manner, past, present, or future, be construed otherwise. See the Uniform Commercial Code, Article 3, 8, and 9. Should the respondents allow 10 calendar days or 20 calendar days total if the request was made by signed written application for the additional 10 calendar days to elapse without providing the requested necessary proof of claim, the respondents will go into fault, and the undersigned will cause to be transmitted a notice of fault and opportunity to cure and contest acceptance of the respondents, wherein the respondents will be given an additional 3 days, 72 hours to cure the respondent's fault. Should the respondents fail or otherwise refuse to cure the respondent's fault, the respondents will have been found in default, and thereby and therein the respondents will have established the respondent's consent to the agreement, to the facts contained within this conditional acceptance for value and counteroffer claim and proof of claim, as said facts operate in favor of the undersigned, that the judgment of alleged court of record wherein an above referenced commercial blah 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 criminal civil case is void ab initio for want of subject matter jurisdiction of said venue, sufficient document information and affidavit in support thereof for want of establishing a claim of debt, want a relationship with the source of authority for said statutes, laws, want a privity of contract or contract itself, improperly identified parties to said judgment, as well as said dispute matter, the respondents agree and consent to the respondents that the respondents does have a duty and an obligation to the undersigned. The reason why that section is there is because that's what the law requires, that there must be an obligation between the parties to respond to each other. So here the respondents agree and consent that they have a duty to you. As well as the corporate government department agency construct, respondents' representative serves to correct the record in the above referenced alleged commercial civil cause, and thereby therein release the indenture, however termed or style, upon the undersigned, and cause the undersigned to be restored to liberty, and releasing of the undersigned's property, as well as all property held under storage contract in the name of the all capital name defendant within the above referenced alleged commercial civil cause, within the alleged commercially bonded warehousing blah blah blah, sorry, not the blah blah blah, DBA for the commercial corporate government construct, DBA, the United States, that this presentment is to be construed contextually and not otherwise, and that if any portion of this or provision contained within this presentment, this self-executing, binding, irrevocable contractual agreement coupled with interest, it shall in no way affect any other portion of this presentment. At the arbitrator, or it's supposed to be that the arbitrator is permitted and allowed to adjust the arbitration award to no less than 2 times the original value of the properties associated with this agreement, plus the additional fines, penalties, and other assessments that are deemed reasonable to the arbitrator upon presentment of such claims, supported by prima facie evidence of the claim. What we did is we didn't want to put it to the point where the arbitrator could do you wrong by sitting up there and giving you a dollar judgment. So we put a limit on the arbitrator that they cannot go any less than 2 times the actual amount, because you are permitted to seek treble damages. So we put a limit as to what they can do. Like I said, this was designed to protect you. This was not designed just to be writing up some piece of stupid paper. Now, remember, when we speak about this thing being construed contextually and not otherwise, that's because if there is a typo, if there is a misspelled word, that does not invalidate the agreement. Okay? You need to understand. That's the point. That's what was trying to be made, is that it could not be invalidated by such. All right. Now, let's continue to explain to you why this works. Please be advised that as much as the undersigned has secured the interest in the name of the all capital name, the defendant, as employed, used upon the face or within any of all the documents, blah, 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 we're basically letting them know about the common law right. That's our property. You don't get to use it without our permission. Okay? And ladies and gentlemen, here's the thing. The reason why this works, the reason why it worked with the gentleman, is because the law requires that the other party receive notice. That's why you don't need to serve it upon them with the, what do you call that thing, signature confirmation or certified mail. It doesn't need a signature. All it needs to be is mailed, and you to have proof that you mailed it. So we're saying send it priority mail, $6.70 on average. That's all you have to do. Just put it in the mail. Print up the papers, print it in the mail. And ladies and gentlemen, I have my printer prints on both sides. So mine is, it may be 90 some pages long, but it's only 45 pages when I drop it in an envelope. So that way I'm not having to stuff the envelope and put too much in there. I just send them the contract. I want them to ignore it. The best thing in the world you could get with this contract is for them to ignore it. Because once they ignore it, it's the same as you. When the court sends you something and you don't respond, do they not issue a warrant for your failure to appear saying that you didn't respond? Tax collector or a debt collector sends you something and you don't respond to that, do they not go to court and get a judgment against you? That's what you're doing. They don't respond to you, you're getting a judgment from an arbitrator. The unique thing about the Arbitration Act, you can find that act under Article 9 and Section 1 through about 32. But if you look at the Arbitration Act, ladies and gentlemen, it clearly speaks as to the arbitrator having the power of a judge. As a matter of fact, this document even documents that the arbitrator is immune, that you cannot go after the arbitrator just because you didn't like what the arbitrator did. So let's do that. As indicated by this agreement, all the parties associated hereto directly and or indirectly agree under penalty of imprisonment for no less than 5 years to hold the arbitrator and the arbitration association associated with this matter totally and completely immune for all consequences resulting from his or her carrying out their duties associated with the instant matter. That to protect the sanctity and the honor of the arbitration system, the parties agree that the arbitrator's decision shall be final and binding upon all parties, and that no party shall attempt to retaliate, challenge, appeal, dispute, charge, allege, complain, or otherwise cause harm, stress, burden, conflict to the arbitrator and or the arbitration association with any matter associated thereto directly or indirectly, heretofore, henceforth, and any such attempts shall be held null and void, that arbitration is the exclusive remedy for the parties, and that only the original arbitrator or that person's designee will have the right to reconsider and amend the arbitration award, but only under the terms as specified within this agreement and not otherwise. No other party except the arbitrator shall have the right of determining the validity of this contract, as the parties agree that this contract is a sufficient agreement determining and detailing the consensus and understanding of the parties as of the institution of this agreement, which shall take full effect 10 calendar days after the receipt or upon default. That was a whole lot, wasn't it? Many of you are going, well, I don't understand what all... Basically, it's just saying that arbitration is the only remedy concerning this contract. They cannot go to court and ask the court for a judgment, nor can anybody go after the arbitrator or the arbitration association. They are immune. Everybody has waived and cleared them of any liability. That's why we're going to suggest, and we are just suggesting it, you don't have to. We're going to suggest that you use SAA. Now, the unique thing about SAA, they are still charging the full amount of the arbitration fees, but they only receive $500 at first. At the end, if a payment is made, then the rest of the monies are paid to them for their services. But if no monies is ever paid, you don't owe them a dime. Okay? Many people are telling me that they don't have the $500 to go to SAA. But if you go to another arbitrator, you're going to be spending $2,000. Why? Because they get 4 hours guaranteed. They're $500 an hour. So they are 4 hours guaranteed plus their administrative fees and costs. Okay, SAA is not that. Now, you can't pay for SAA services just yet. Sorry, that little vacation I went on, I'm the person working on the website, and that's all volunteer time for me. And so I haven't had the time to work on the contract and the website and all the other things and answering all the emails and all of that stuff. It's a lot of work on my plate right now. So people, please be patient. You will be able to clickety on the SAA website. Now, let me explain something to you about the SAA website. I'm going to go there for just a moment, then we'll come back here. But that's basically everything about that contract I wanted to show you. The idea was to make sure you knew that it protects you. Okay. Oh, really? It ain't up. Okay, there it is. This is the SAA website. You'll find it at SAAlimited.com. Okay? When you go to the SAA... didn't have to do that. I'm already on the front page. Come on. Yeah, I hit that button. I shouldn't have. It's gonna reset the page because I just refreshed it. Okay. Here is the amounts. There it is. It went back to the front page. Come on now. Stop playing. It's playing with me, y'all. Ladies and gentlemen, any site that I'm associated with, we don't keep any of your data. We don't keep any of your keystrokes. If our web host does, that's not on us, but we don't do it. We don't give out any information concerning any of the people. This is a legal matter, and the arbitration process is protected under immunity, so there is no search warrant or anything that can require or compel them to provide information. There are several different programs here. The one that's complicated means that if there are multiple parties, like somebody want to add their brother and sister and cousin and uncle, and they want to have 100 different contracts associated with the same contract, that's complicated. Multiple parties, meaning that if you want to bring your mother, your brother, your sister, your cousin, your uncle, you can do that. But see, we are looking for the people who, let's say, you want to do it for yourself and your family and about 4 others, then that's the standard. You want to do the complicated one, the one that it's got so much evidence and got so much paperwork and it's going to take 5 or 6 days to arbitrate, that's the complicated. The one that's multiple parties, where you want to do it for your whole family, the generations to come, that's the multiple parties and complicated. Okay? So let's do this. For the standard, it is $100 per hour, plus a $100 administrative fee. Why? Then there is a $100 technician fee. Now let's go 2-hour minimum. So $100 per hour with a 2-hour minimum, that's $200 there, plus another $100 for the administrative fee, that's $300, plus $100 for the technician fee, that's $400, plus the $45 for the processing, archiving, and mailing. See, this is them keeping that administrative record for you and mailing it out to the parties. Now let's say you have 15 different parties. There is a limit. After a certain number of parties, then you will have to pay for the extra. Okay? The extra mailings. But for right now, they will do up to 5 parties. Now I want to make sure, because see, there's a $45 fee for processing and archiving and mailing of documents. So if they're going to take care of 5, 670 times 5 gets you right about that $40 mark. Just want to make sure, because 670 is actually $7. 7 times 5 is $35, people. You don't understand. We have to pay for the copies. We have to print the copies. Let me show you how the contract works. You're going to make 2 copies. You're going to sign both copies. Then you're going to make a copy of the signature page. That's the one you send to everybody else. You do not send them an original signature. The original contract you keep. You just send a copy, because all you're doing is giving them notice of the contract. That's it. Just that simple. You send them a copy of the contract, and you store that original contract in a nice, safe place. Then when it's time for you to go for the arbitration, or if you want SAA to do the contract and mailing it out for you, then you send them a copy of the contract, plus proof that you've sent them in the mail a copy of the original contract. Okay, because you're going to have to send them the original. They're going to need the original contract. But you send them the copy at first so they can mail it out to everybody for you. Then you send them the original, and you send them the original by priority mail. Okay, just that simple. Those of you who know me, who've been watching my videos for EEON'S, did you hear how he did that? He said EEON'S. Anyway, I'm not here to get over on you, nor will I allow any other organization to get over on you. There's been a lot of training going on with the staff, making sure that they are not going to ever attempt to take advantage of you, because I won't allow it. Look, those of you who know me, you understand that there are just certain things I'm not going to allow. Plus, the fact that I say I'm one of Jehovah's Witnesses and I use the name Jehovah when referring to my God, there is no way in the world I could sit up here and be a fraud and use his name. That's called bringing reproach on Jehovah's name. He doesn't tolerate that. Plus, he would not allow me to do that, because if I did that, I would lose my reward. Some people who are listening to these videos understand exactly what I mean by when I say I will lose my reward. And I'm sorry, none of you are worth losing my reward over. It's too important. Let's get back to the contract, because that's what this video is designed to do, is to explain to you guys why this thing is so unique. You see, before we were doing contracts, but we weren't including the arbitration clause. Now, under the Arbitration Act, if the contract has an arbitration clause, then the parties are bound by the arbitration clause. So that's what we did. We included an arbitration clause, and we bounded the parties by this clause. But hold on, let me give y'all some of the case law, because y'all need to see the case law. International accepted principles of law governing contractual relations. That is the arbitration issue. If the contract, valid or otherwise, contains an arbitration clause, then the proper form to determine whether the contract is valid or not is the arbitration tribunal, i.e. only the arbitrator can determine whether the contract is valid or not. And you've already seen we put that there. Now, we talked about the whole process being administrative, but private, not administrative theirs. So that any determination by the arbitrator is binding on all parties, and that all parties agree to abide by the decision of the arbitrator, that the arbitrator is to render a decision based on the facts and conclusions as presented within the terms and conditions of the contract. The arbitrator has to go by the contract. The grantor's intentions is law of the contract. Any default by any party must be supported by proof and evidence of said default. That default shall serve as tacit acquiescence on behalf of the party who defaulted, as having agreed to the terms and conditions associated with the self-executing, binding, irrevocable contract coupled with interest. That the arbitrator is prohibited from considering and relying on statutory law, as it has been held that any time a party relies on the enforcement of statute, they possess no judicial power. The arbitrator has the same power of a judge. So the arbitrator cannot rely on statutory law, because then they would have to only go by the will of the agency. That's what you're having with the other arbitrations. They have to go by statutory law. Well, the arbitrators associated with this contract are prohibited from going according to statutory law, only if the contract says they have to. Now, you're saying, but there are statutes all throughout this. That's correct. Statutes where everybody agrees to the facts associated with the statute, which also includes the fact that the statutes were not properly enacted. Okay? Some of the aforementioned cases are not published. However, these are still fundamental principles of law. And one of the fundamental principles of arbitration is that the arbitrator sits as a judge over the facts. And as such, to preserve the sanctity of the process of the arbitration, the arbitrator receives the same immunity as a judge and is exempt from prosecution or review unless it can be proved that the arbitrator intentionally ignored the evidence and acted in conspiracy to defraud the parties. Okay? And you won't be able to do that with SAA, because their arbitrators know that they must rule fairly and they cannot judge anybody based on anything. Okay, so when you go over this document, you'll see, and that notice the agent, notice the principal, and all of that stuff. We've included that, but didn't need to do that. Okay, now these are all the notices, and that is the end. It really is that simple. All of this other stuff is just in here. We put in enough proof of claims to where they can never, ever, ever come. And remember, we also added this junk. That Department of the Treasury where they say the dollar bill is worthless. Okay, we added it there. Where's the other one at? It's here twice. Come on now. Oh, I lost it. So I can't tell y'all where it is. But this is just to let you know so that you guys are understanding and aware that we weren't going to leave you in a lurch. We were going to cover all the bases on this because we know that the people who are incarcerated, and they, especially if they have not committed a violent crime, did not cause harm to another, and are still in jail because somebody said they were selling drugs. Ladies and gentlemen, as I said before, I am not a drug dealer, not a drug seller. I don't agree with drugs. I don't condone drugs. But this is what I will tell you. The person who sells the drugs to the person who is buying the drugs understands something so that you all will get it. They're not harming anybody but themselves. They have not violated common law. Common law says do to your neighbors as you want your neighbors to do to you. Well, the two are selling and buying drugs from each other. They're doing what they want to do to each other. They are following common law. Now, this document, as you see, it goes to your state, then it goes to the United States Supreme Court, then it goes to the United States Congress, then it goes to the United States Executive Office of the President, and then it goes to the United States Department of Defense. And it goes to the United States Attorney General. All the parties it's supposed to go to. Okay? Plus the parties that are listed up top. Okay? Plus, it goes to the parties listed up top. You guys have been hearing my phone chiming. People, I'm amazed that people keep subscribing to this channel. Like I said, there's no advertisement done for the EON channel. It is a channel that was just put together just to give information to people and to make sure the information was continually put out there. Ladies and gentlemen, all of the spots that are yellow, like I said, you have to put in the correct information and then unhighlight it. So every spot that has yellow, you put in the correct information and unhighlight the information. Okay? That being the case, this is the complete document. Now, this is, many of you don't have, Microsoft Office 2016, and this is DOCX format. And you know what? I'm sorry, there was something we were supposed to do. Ladies and gentlemen, we're going to be putting this back up tomorrow. Those of you who downloaded it already, and it won't be until tomorrow, sorry, I won't be able to put it back up until tomorrow. What I have to do is this right here. We're going to ask that you guys put it in like this right here. It says size. Come on, size. Yeah, that little chiming is people subscribing. And so this thing has been going off all day. So I guess we got people's opinion. I mean, we got people's attention. So I'm going to turn the volume down on that so it won't keep doing it. All right, we're going to do this 8.5 by 14. And the reason why we're going to put this on legal size paper, because it is a legal instrument, a legal agreement. Mine was not on legal paper, but I told you we're doing you all different. Okay? So now this is on legal size paper. I'm going to tell you, put yours on legal size paper. You don't have to. I am making a suggestion. By the way, this right here, file on demand, okay, that has a lot of weight. All right? That's all I can tell you. As a matter of fact, I went to the clerk of the court and I was filing some documents last week, and they tried to give me a hard time, tried to give me a very difficult time, and I ended up having to explain to them that they needed to get out of my way because they were causing me some problems. And they eventually understood, and they filed the documents. File on demand is exactly that. Now, what I want you all to understand, you're not filing this anywhere, except for those of you who are incarcerated. You're filing this into the case. You're not looking for a response. Ladies and gentlemen, if they don't respond directly to this document, if they don't answer every single question, then don't worry about what they respond to. They can respond and ask all kind of questions. Okay? They can ask, what is this? We don't understand it. They can do all of that. That ain't got nothing to do with it, because you've already explained everything that it is. It's all in the document. So you don't have to write them back or anything. You just send them their notice of default, because it says if they give any non-answer, any general answer, and that we don't understand what you're talking about. If they didn't understand, then let me explain to you how they would not understand. They would be, well, I don't understand page such and such, the section that says such and such, and then and page such and such, the section that says this, I don't understand that, and the page such and such, the section that says that, I don't understand that, and the page such and such. They would go through each one and tell you what part they didn't understand. But if they tell you they don't understand, they just speaking about the whole thing, don't worry about it. Okay? Do not worry about it. You need them not to respond. You need them to accept the agreement. Because the moment they don't respond, that's acceptance. You need them to accept the agreement. So once they accept the agreement, you still got to send them a notice of fault, opportunity to cure. Now, how do you do a notice of fault, opportunity to cure? There's one on the website, but it is just simple. You take and send them the document and you say, hey, you're in default. You need to provide proof that you did not receive the original notice. And if you did receive the original notice, then you don't have to do anything, because you're accepting the agreement as is. You have 3 business days, 72 hours to respond to this communication with that proof that you did not receive the original communication. And that's it, ladies and gentlemen. That's it. You don't have to do anything else. And then after that, you just contact the arbitrator. Let the arbitrator take care of it from there. No, wait. What happens once the arbitrator comes to a decision, once the arbitrator reaches their conclusion? What do? How do you enforce it? How do you get the funds? What I want to stress to you, don't worry about getting the monies right now. Not right yet. What we need you to do is to make sure you get your contract done first. Then we can go after the ducats. Then we can go after the dinero. But after that, you'll go and you'll read the Arbitration Act, the Federal Arbitration Act. Just type that in Google. Study up on arbitration. Understand what's required. Understand what's not required. Do your research first, because it tells you how to get your monetary damages. Okay? All right, ladies and gentlemen, like I said, we are hoping that other people will start their own arbitration associations. It's not that we need someone in competition with us. We need for people to understand how ingenious it was for somebody to start an arbitration association to help people with documents and contracts like this, to help the common folk. And so if other people wanted to get started, you have my blessing. Now here's the thing. I can't help you. A lot of people are trying to contact me, and a lot of people are trying to contact SATCOM to get me to answer questions. Ladies and gentlemen, because SATCOM is putting this up on SATCOM, SATCOM cannot help you unless you acquire the package from SATCOM. We haven't even given it a name. Okay, so we've been getting emails upon emails about people asking questions about this, but we really do need you to go over there. I need you to go over the videos that have been placed online. There are too many of them. For the last 3 months, I even did the video, if one is to be erased, this is how it's going to happen. This information right here, this is going to piss people off, and I don't care. I don't care. What's happening is I told them to leave me alone. Ladies and gentlemen, I literally told them to leave me alone. I said, people, I'm tired. I don't want to do this anymore. I'm walking away. And they said, oh, no, you ain't. And I said, yes, I am. Leave me alone. They said, we ain't leaving you nothing alone. And I said, well, you're going to have to leave me alone, because if you don't leave me alone, I will start telling people what they need to do to get out of your system. They didn't leave me alone, ladies and gentlemen. So the document I'm working on now is the document that takes care of the infant estate. It's just as long as this one, has different case law in it. Doesn't have the thing about being arrested. It does have some things about people being arrested, because some of that is necessary. But it includes the information on the infant estate. And it's designed specifically for that. As a matter of fact, when I do that document, that's going to be on legal size paper as well. It will have all of the agencies that you're supposed to send that document to. Okay? Remember, this whole idea is how to get out of the system. You're asking, have I done it? I did mine months ago. But the one I'm doing for you will be more ironclad than mine, because I was rushing to get my stuff out. Because I wanted to make sure, because see, if, like in the past, if I had not protected myself, then I could not help you guys eventually. Well, now I can protect myself. This is the reason why I bonded out of that facility, so that I could finish this for you guys. So if you got somebody that you know is incarcerated, here is your ammunition. By the way, we're providing it for you free of charge. So it's not costing anything but, what, probably $40 to mail it out to everybody? So what are you waiting on? All you got to do, hold on, let me show you, because many of you got people who are incarcerated, so let me show you. All you got to do, the first thing you got to do is change that number, create your own number, and then what you do is you go up to the replace section. So the first thing you do is, let's say this is the number. Oh, I don't like that C. That thing is supposed to be smaller. So watch this. Got to go there, TH, do that. Yeah, somebody said, there's an easier way for you to do that. Don't worry about it. Okay, that's the C I want. Now we put that back there. All right, now watch this. To change this number, and you're going to do the same process with everything else. See that number right there? Okay, now watch this. Hold on. Not that one. I need that other number, because it is 2 numbers. Remember I told y'all going to have to change it? Come on now. And you don't want the same contract number. That will hurt you later. So that's why you want to change up at least 7 numbers in the document. Hold on now. All right, see that number right there? Watch this. You're going to hit, not select, you're going to hit replace. Okay, this is the number I want to replace it with. So I'll do V. And then I have to do highlight, because it has to be highlighted. So highlight. And then I'm going to come back here, I'm going to double click so that I can select this, because it's 2 different fields. So I have to copy and come on now. All right, and paste. Now I want to change this number to this number. So this is the original, and this is the one I want to replace it with. I'm going to hit replace all. Should be about only 1. There you go. You see how it's replaced. And you're going to do the same thing. Now, the only thing is you're not going to highlight it because it's not necessary for you to highlight it. I had to highlight it because this is the template that's going up online. Okay? So I had to highlight it. But you don't have to highlight it. You got it? All right. Now, that's the first thing. The other thing is up here, everything in yellow, that's all your information. That's all you got to change. You have like maybe 7 pages on this 90-some page document to change. The rest of the information in the middle, you don't have to worry about. You don't have to put your particular information, your particular circumstances, because this has nothing to do with your particular circumstances. Okay? It has nothing to do with your particular circumstances. What does this have to do with? Oh, and it does even include this infant estate. Okay? It does include the infant estate, and I think this one also does man or woman. Yeah, I think that we took care of this to make sure that it's applicable to men and women. And the part where it needs to have the person indicate that they're a woman is, I think, this paragraph right there. Okay? This is the only one where you're going to find that. Everything else is general. It's a general contract for a reason, so that it can be applied to each of you, so you don't have to go through the whole document changing everything. All right? So this was done for you all. But the idea was, the more of you who put this out there, the more we get their attention. The more they will have to stand and pay attention. Because let's say they say that this document is invalid. Let's say that they say that we couldn't do this, that this was wrong, that we didn't have the authority to do this. Ladies and gentlemen, they deny us this, they deny us the arbitration award. That means they now have to correct all the other arbitration awards. They have to correct all the other contracts they received. This is their catch-22. You tell us no, you have to tell everybody else no. You deny us, you have to deny everybody else. This is what we're doing to them. This is what we're doing to them. Okay, again, the process is simple. The only thing you're looking to do is just mail out the contract after you edit and put your information in the contract. Now, many of you, again, are going to want to change the terms of the contract, and I'm promising you, leave the terms of the contract. Do not add all of that other junk into it. The dollar amount, yes, you can indicate the dollar amount, but again, this is the incarceration contract. All you had to do was do what we did. Put the $1.6 million a day. You don't have to put how many days. You do that to the letter to the arbitrator, because that's where the arbitrator and you come together, and you tell the arbitrator the amount you're seeking in the application. Ladies and gentlemen, I also have to do the application, so let me show you. We had to find a software that can do the form, and so this is Adobe, and so I'm going to be playing around with some of their forms, but this will allow you to fill in the information. Okay, so that's what we'll be working on. I'm not going to be using this form. Don't know what form we're going to be using yet. I don't use Adobe, but I saw a guy doing a video and he showed how Adobe already has the form put together, and so we're going to do it to where all you have to do is just type in and click and type and click, and your application for the arbitration is taken care of. Okay, so that's the amount of work that's being done. And remember, I haven't taken a break. Even after that ordeal, the first thing I started doing, and the people who came to my rescue and came to help me, and because I paid for the bonding, I paid for the so-called 10%. I don't have those type of funds, so that has left me broke. No, I don't need your donations. No, I don't need you worrying about me. No, I don't need your money. Please understand, I don't need it, so don't offer it. I have people, well, I need a consult with you and I'm willing to pay. I don't care if you're willing to pay. I didn't ask you because you're willing to pay. What do you mean? Just because you're willing to pay, I'm supposed to drop everything I'm doing to help you? I got somebody talking about they're getting ready to be kicked. The parents' home is getting ready to be sold at foreclosure sale tomorrow. Told him I don't do Hail Marys. You don't call me at the last minute. You don't contact me at the last minute. I told people, ladies and gentlemen, I'm not helping anybody one-on-one. I'm doing too much here as it is. I don't have the time. You guys are not going to give me that early grave. I'm already headed to the grave from the cradle as it is. Okay? But you're not going to do that to me. I'm not going to allow it. So stop asking me to help you, because I'm giving you all the help that I can right now. As a matter of fact, I'm helping you with this. If only you knew. You got a foreclosure situation. We've already put the document up for you of what to send. We've already gave you the contract. Remember, this is a conditional acceptance of their offer, because what they have come to you every single time they come to you with a change of terms and conditions of contract, then you have the right to accept their change in terms and condition. That's all this is. You're accepting their change in terms and conditions. Okay, so that's what you're doing. And you have the right to do that, because when somebody changes the terms of a contract, you don't know that you have the right to conditionally accept it. Somebody give you a ticket, they're changing the terms of the contract because they've just given you an adhesion to the contract because it's another agreement requiring your signature. So that gives you the right to send them this notice of change in terms and conditions. Your conditional acceptance of their offer. So if you got a mortgage and you know you have mortgage problems, you know you're going to be foreclosed on next month, start the process now, because when you go into court, you show them your contract. Ladies and gentlemen, this is a binding agreement. You go into court, you show them your contract. They have their contract, you show them your contract. The judge does not get to determine whether or not this agreement is binding. You point out that this agreement says that we can only go through arbitration. We can't go through the courts on this agreement. They cannot circumvent the arbitration process. And the judge is going to say, well, have you chosen an arbitrator yet? No, I have not. But that is completely left up to me according to the terms of the agreement. I get to choose the arbitrator because they've consented to allowing me to choose the arbitrator. Well, are you saying that you're going to impede the obligation of a contract? You don't get to review this contract. You don't get to determine the validity of this contract. Only the arbitrator gets to do that. This contract has an arbitration clause. That is reserved for the arbitrator. Just that simple, people. So I hope that this helps to solidify and give you guys a better idea of the process of why this works and of how you've got nothing to lose. Look, ladies and gentlemen, there are a lot of people out there that got all these processes telling you that this is going to work, that's going to work, and you're paying all of this money. You're paying $4,000, $3,000, $2,000 to these people to do nothing for you, and they're not accomplishing anything. They're buying you a reprieve for a couple of weeks. I'm not trying to buy you a couple of weeks. I'm trying to make sure you save everything for as long as possible. And look, I'm not asking you for a dime. Go ahead, take a look. I've not asked you for a dime. I spent all of this time on this stuff for you all, and I'm not asking you for a dime. And I promise you, it has taken me 9 months to make sure that this process is ironclad. That's why I'm daring anybody to find a flaw. Go ahead, find a flaw. Well, no, if you do the arbitration, they get to do this and they get to do... No, they don't. Do you know that somebody can ask for a stay of the arbitration award? They can, but the only problem is we made it to where the exclusive remedy is only at arbitration. So if they want to stay the arbitration award, they must go to the arbitrator. They cannot go to the courts. That is the whole point. The only thing that can be done through the courts is the confirmation of the arbitration award. That's the only thing that can be done through the courts, because that's the agreement. All right, ladies and gentlemen and ladies, I said we were going to probably be going into 2 hours, but we're not, because I'm too tired. I just wanted to do this so that you guys will know and have this information and have it available. So it is my hope, those of you who are riding to work and who are sitting on that bus, because I got one guy who rides a bus, and he he drives it and he rides it at the same time, and he just sitting up there twiddling his thumbs, running into walls and people. He had 3 accidents already this year, y'all. And he a bus driver, and y'all gonna be sitting up there on his bus talking about y'all safe. Y'all ain't safe. He says none of the accident was his fault. Don't believe him. Don't believe him, y'all, because y'all know 3 accidents in 1 year. Come on now, it's gonna be like it ain't his fault. How everybody? He must have that magnet on his bumper. Okay, because he getting into 3 accidents in 1 year. Okay, ain't nobody that unlucky. Just kidding. All right, ladies and gentlemen, it is asked that you have a good afternoon, good night, good morning, good day, good everything, anything, and as long as whatever it is, it be good. Why don't you guys go ahead and take care of that? Thank you for allowing us to bring this information to your attention, and we're out of here.